right, and then we would next have People v. Brandy Schrader for sentencing, file 24-6828FH. Mr. Clean, have you had a chance to review the pre-sentence report and recommendations?
Yes, Your Honor. I found the report to be factually accurate and relevant, well written by the agent. I found the scored in the sentencing guidelines to also be accurate, scored at 0 to 11 intermediate sanctions.
All right, thank you. Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
Your Honor, and looking at over earlier, the only objection I would have is to OV-19 being scored based on her resistance and force used at the time of her arrest. I would ask that it be scored at 15.
Mr. Clayton, the people are are you saying for that on the R&O count or also on the FA at the time?
On both.
Okay, the people are objecting to the scoring of OV-19 at 0 points for both the attempt FA and the R&O.
I don't think it changes the guidelines on the attempted FA, but it will on the R&O.
Okay, Mr. Clayton, people's or the defense response.
I just want to, let me get to OV-19. I didn't know this was an issue, but
No,
I think you can address it. Let me just to the 15-point scoring. I'm not, and I'll ask Ms. Goodrich to articulate her position with regards to the scoring 15 points in OV-19. 15-point scores. The offender used force or the threat of force against another person or the property of another person to interfere with, attempt to interfere with, or that results in interference with the administration of justice or rendering emergency services. That's 15. 10 points is the offender otherwise interfered or attempted to interfere with the administration of justice or directly interfered or violated personal protection, or opposite. The last part of that doesn't apply to this. First of all, I don't think it scores in the attempted FA at all because it's offense specific. The two offenses, although intertwined closely in time, were completely different. One occurred and then the other one occurred sometime later. So through the passage of time, I think it attenuates enough that it wouldn't be scored on the attempted FA. Whether it scores on R or no, I don't think it scores at all. It would score 10 points versus 15.
All right, thank you. Well, I'll grant in part and deny in part the prosecutor's objection to the scoring of OV-19. I think People v. McGraw says that we score offense specific, except for certain offense variables, and OV-19 is not one of those McGraw variables. We can consider post-offense conduct. But I do agree with the defense that if it scores, it would score at 10 points, not 15. I don't think there was sufficient force or threat of force against the officer. It was more of a resistance to his commands and pulling away as he was trying to arrest her. I guess in a hyper-technical format, that is some physical action that might be considered force, but I don't think that's the force or threat of force contemplated under OV-19. But I would score OV-19 for both offenses at 10 points. On the attempt FA, that changes the OV points to 30. It doesn't change the level or the range. In the R&O, it increases the points from 10 to 20. It increases the level from 2 to 3 and the range from 0 to 11 to 0 to 17. All right, Mr. Clayton, anything you want to say on your client's behalf?
Well, if you could, just. So, just understand the court. I thought the court said two separate things. Did the court say that under McGraw it is not scored under the attempted FA?
No, it is. It is. Under McGraw, we can consider, well, OV-19, for OV-19, we can consider post-offense conduct. It's not subject to the McGraw limitation, as I understand it.
Okay.
So I am scoring 10 points for both sentencing offenses.
That's fine.
It doesn't change the range in the attempt FA. But it does change the range in the R&O from 0 to 11 to 0 to 17.
Right.
Still in the intermediate section.
Right. And I'm not, I understand. I haven't briefed the issue. I understood the broad would be like bond violations, things like that, but I understand what the court's doing. I have no objection. If the court adds the 10 points, it does change the intermediate sanction of all, that's fine. We can proceed to allocution.
Okay, go ahead, Mr. Klein.
Thank you. I've read the pre-sentence investigation report. I've read the victim's impact statement in this case. And I know that Mr. Hudak does not like my characterization. I can read his statement. He doesn't like my characterization of this as being a property dispute. What Mr. Hudak doesn't understand is sometimes I don't use words right. As I look at it, but for a disagreement with the property line, this likely would have happened. I think it goes deeper than a property dispute, but I do think that that's the impetus for why they had a disagreement. So as inartful as sometimes I am in my allocution, I do apologize for what it's worth. I didn't mean to minimize what happened here because I think what happened here was potentially serious relating to the offense. But as I frequently do in front of Your Honor, I ask the court, as you always do, is look at the offense and the offender. The offense is a situation where Ms. Schrader had a gun. She did not point it, even by the statements. She didn't point it at him, just displayed it. In my heart of hearts, I'm happy with the resolution we came up with. I do think it was more of a brandishing, but we're not going to run the risk of a felony firearm conviction, are we? So we take what we got, and I was happy with the resolution. But I do think, and not that I condone brandishing firearms, but brandishing firearms in Michigan's misdemeanor, flows itself a felony. And sometimes justice lands right smack dab in the middle, and that's where we are. Do I think that Ms. Schrader intended to scare Mr. Hudak? I don't think so. I think she was upset. Maybe she was misguided in whether or not Mr. Hudak was on her property, on his property. I don't think that matters. It's not the issue of whose property on this. I don't think it's really important, but I think it's important. Now, I've talked to Ms. Schrader about this. I think what's important is that these people do have an adjacent property line and they have to figure out how to get along. I've talked to Ms. Schrader about her anger issues. If she needs impulse control, she's working with that. She's working with the VA. You know, I can't crawl inside her mind and experience the things that she's experienced. It's outlined in the pre-sentence investigation report. And because this is broadcast on YouTube, I don't want to make part of a record, but she's been through some trauma. I don't justify anybody's actions by their past, but I do understand them as well as I can, having not been in her shoes. What I can tell the court is that Ms. Schrader, when we've talked, has been very respectful to me, very respectful to the process. She took responsibility for what she did. And I think that should be noted. So in balancing the four goals of sentencing, punishment, rehabilitation, protection of society, and sending a deterrent message to others, I think that the primary focus of the sentence could be and should be rehabilitation and helping Ms. Schrader, if faced with troubling situations, not to resort to this. There is a deterrent message in this court. This court takes a dim view, and I know this court takes a dim view of introducing firearms into heated situations. Only bad things can happen. I don't think that falls silent on Ms. Schrader's ears. I think she understands that. You know, I don't see this, and this is my opinion, I don't see this as a strong punishment case. I do understand that dissuading this kind of future conduct does provide some measure of safety and protection of the public. While I understand that this kind of conduct does cause public safety concerns, as I look at that goal of sentencing, not only do we look at the past conduct, but future likely performance by the defendant. So with all the factors, everything being scored, everything being taken equal, the offender and the offense, I think this is a case that calls heavily for a probationary sentence to help Ms. Schrader stay on track. The probation recommended is a short term, in my opinion, but nonetheless, I think probationary sentence would help her. There will be ramifications that come from this in other ways. The only concern I have in the probation recommendation is I've looked at GIS mapping of these properties, and I don't know exactly where the 500-foot delineation from the house administrator's property is. Maybe it's a non-issue, but I think simply her not entering onto his property. But having said that, I also think the court could put safeguards in place that she's not contacting directly or indirectly Mr. Hudak, so that any of the concerns like trail cams and things of that nature could also be remediated in this court sentence in that measure. So I know the court doesn't have any questions for me, but if you did, I'd answer them. But I believe Ms. Schrader has a statement she's prepared to discuss with the court.
Okay, thank you, Mr. Clean. Ms. Schrader, you don't have to make a statement, but you may. Is there anything you want to say?
Yes.
Okay, go ahead.
Thank you very much. I do want to acknowledge that this could have been handled differently. I understand that. I thank you for your consideration and wanting to know me as an individual and what makes me tick. And I have full confidence that you will give me the appropriate sentence. That is all.
Thank you, ma'am. Ms. Goodrich, people's recommendations.
Yes, Your Honor, if the court would allow, Chris, I would like to make a statement.
I would. Mr. Hudak, you want to come forward to the podium? And Mr. Hudak, I did have an opportunity to review your written victim impact statement and the attachments to it. Go ahead with anything you want me to know.
Thank you for reading it. This has been a pretty traumatic experience for me. On my own property, I was assaulted. I'm going to call it an assault. Even though she wasn't standing on my property, Ms. Schrader, she was actually standing on Norm Bordeaux's property, trespassing on his property. This didn't have to come to this if she'd have been a good neighbor or her husband be a good neighbor and come to me and ask me where the property line was. I've lived there 60 years. I knew where the line was. The line has been there forever. To Norm Bordeaux's property. He had his surveyed. It doesn't, the property lines don't go this, they go straight to where my line was. Good neighbors should have come over and asked me where it was, but I had to come home from a hunting trip and find posted signs in my trees, nails in my trees, metal stakes in my tree, on my property, ropes on my property, and telling me to stay out of my property. Good neighbors don't do that. This has been very traumatic. This has changed the way that I live on my property. I'm a CPL holder. I didn't have a weapon with me when she confronted me for the second time on my property while I was putting in a new property stakes that had disappeared prior to after November 18th, when the first time my stakes, or the stakes they put in, I took back to her house and tried to have a civil conversation. But I was threatened there by the first warning, the second warning, and the third warning, I get to shoot you. We're talking a weapon here. A weapon was pulled on me, waved at me. I don't know how many verbal sentencing she had. She didn't hold the gun on me. She waving it around in a direction and giving me the peace sign while she's smoking a cigarette. I had to use my excavator bucket while I was in a 911 to protect myself while I backed away from her. I witnessed her take off when the cops came, and she had to take off in the wrong direction, which Mr. Stacks was able to get her in custody. I watched Mr. Stacks get abused verbally and almost being kicked while she fought to the car. Another deputy had showed up. This has changed the way I live, because now when I go back on my property, I have to carry my weapon. I shouldn't have to carry my weapon, thinking that maybe Miss Schrader would show up again out of nowhere with another gun. What's she going to do the next time? This isn't somebody walking across the street charge. She was charged with 5 charges. Now we're down to 2. feel it's wrong that we're down to 2, in my opinion. But of course, we plead bargain stuff nowadays. Good neighbors don't pull guns on their neighbors. Since she was on parole, or her probation said that she wasn't supposed to be around weapons. Guns going off consistently. What, to antagonize me or something? So I get to call the cops or something because she wasn't supposed to be around guns? Consistently, there's guns going off on their property next to Norm Bordeaux that butts around to me. I can't do nothing about it because I can't prove that they have weapons there. They do. She's not supposed to have been around them. She has been. I would hope this court would, how would I say it? Punish her to the fullest extent of these 2 charges, at least these 2 charges, because she's gotten out of the other 3. I'm not going to change the way I live. That property line was there my entire life. I've been there. There was no dispute on the property line. There was old cedar posts in the ground there. If you had a dispute with it, maybe you should get it surveyed, which I did. And I gained another 15 inches your way. I shouldn't have come to this. But Ms. Schrader took it upon herself to take the law in her own hands and threaten me. Would you please sentence her to the fullest extent you possibly could? And maybe punish her, and maybe she'll learn not to pull a gun out, because I have training too. You pull a gun out, that means you're going to use it. It's the way I've been trained. I'm sure glad the guy above was not, watching me that day, so I didn't have mine. This could have turned out in a way worse situation. Way worse. You don't pull a gun out on somebody, rack it, and start pointing it at them without consequences. Please punish her to the fullest extent.
Okay,
Thank you for allowing me to speak.
Absolutely. Thank you, sir. Mr. Rich, people's recommendation.
Thank you, Your Honor. The defendant is 45 years old. She has no prior criminal history. She's currently unemployed and has an associate's degree. Almost a year now, on December 31st of 2023, the victim had contacted the police because he had discovered that posts had been removed from his property line. Another neighbor was having a similar issue with defendant on the property dispute. The defendant had moved to that location just recently, earlier that year. And as the victim had stated, the 2 neighbors had been there a long time and aware of the property lines. When law enforcement arrived on scene to talk to the defendant, she was argumentative while the law enforcement was trying to discuss the situation. She admitted during that conversation that she had removed the property posts. The recommendation by law enforcement at that time was to simply contact a surveyor to resolve the property line dispute and clear the scene. Later that same day, Chris Hudak, the victim, had to call 911 a second time. And that's because this time defendant had retrieved a firearm and met him where he was putting the posts back in place. She was waving around while yelling at him while he was in heavy equipment to put the posts back in the ground. You could hear in the video her racking the gun while she's arguing with him about the property line. Also, when Deputy Stacks arrived on scene, he had recognized the defendant since he had earlier talked to her when responding to the first 911 call. He made loud verbal commands to see her hands, knowing that she may be armed based on the second 911 call. She was still armed and began walking towards Deputy Stacks while yelling at him. He commanded her to turn around and get down on her knees. She did not obey. And luckily, he was able to quickly grab her. She tensed up and pulled back, resulting in having to secure her by placing her on the ground while she continued to still actively pull away while having a firearm on her. Fortunately, Deputy Stacks was successful in safely securing her handcuffs and located the black 9mm semi-automatic handgun and magazine in her coat pocket. And the goals of sentencing, as Mr. Clayton said, involve rehabilitation, deterrence, and punishment. I think the recommendations for the therapy to address her poor decision-making makes sense, and helping her create a more positive community to better spend her time makes sense. However, because of the dangerous conduct that occurred both against the victim and against the law enforcement officer, I think deterrence and punishment is also appropriate here to address the situation. The defendant in her statement in the PSI takes zero accountability and just simply blames others for what happened that day. I would agree with the recommendation that the no contact order continue. And I would also ask that she be ordered at least 1 year in jail incarceration. Thank you.
All right, Ms. Schrader, if you stand for the court sentence, please. Well, Ms. Schrader, this is, really unfortunate situation that you created for Mr. Hudak, as he described in his letter and as he described today. That's a very dangerous situation that happened out there that day. He may have, if circumstances were different, what if he had been armed with a weapon that day? And if somebody pulled a weapon out and then the evidence showed that, I agree with much of what your lawyer said today. I don't agree with the idea that this is a brandishing case. If you hadn't chambered around, I might agree with that, but that when you chambered around, racking that slide, if you're on the receiving end of that interaction, the person on the receiving end might think they're about to get shot. And so if they were armed, it might well be justified for them to show you theirs. And now where are we? In a shootout in the woods over stakes. So I understand his frustration. It is important in these cases, and I think your attorney articulated properly that we're not trying to excuse any of your behavior. It is important for us to understand some of the things that might have explained or driven those responses, not to excuse your conduct that day, so that we can prevent it from happening in the future. And again, I'm not going to get into the details on this public record about some of the non-public information in the PSI, but some of the ways that you overreacted to situations strike my mind and my experience as a classic response of trauma. And so I think the recommendation from Agent Martin that you engage in some counseling services and particularly to assess for trauma is going to be an important part of your probationary term, because the way that you overreacted to these situations is not a healthy or a normal response. It's a response that I think is driven partly by your bad decision making or your anger about the situation, but also in part at least driven by some of your past experiences that you have not dealt with fully. So I am going to place you on probation with that as a goal. So I'm going to place you on probation for, I think, 18 months, not the recommended 12, for an 18-month starting term. It'll be subject to the terms and conditions listed on page 2 of the pre-sentence report. I'm going to highlight some of them. Completing, obviously, treatment as recommended by your supervising agent. I am going to amend Agent Martin provision 6, no contact. And I think given their status as neighbors, agreed you must not have verbal, written, electronic, or physical contact with Christopher Hudak, either directly or through another person, or enter upon his premises. And I'll strike the remainder of that sentence so we don't have a 500-foot issue if that becomes an issue. You can't possess any weapon. If there's any at your house, they got to be gone. No weapons while you're on probation. And these convictions, I think, disqualify you from purchasing or possessing a firearm for a lengthy period of time. That's proper. There's a crime victims assessment of $130 court costs of $350, $136 in state cost. And there's a monthly supervision fee as well. You are eligible for early discharge from probation at the halfway point. We're going to need some paperwork to explain. And then the advisory guidelines are 0 to 11 and 0 to 17. And, you know, your attorney's correct. I do take a very, as he said, dim view of people that introduce firearms into these situations and creating a danger for folks. Even though it's an intermediate sanction, there's a presumption of no incarceration unless there's reasonable grounds for it. I do think there are reasonable grounds for some incarceration in the danger presented by your conduct, putting the officer at danger, Mr. Hudak at danger, yourself, and then racking around into the chamber, I think is an aggravating circumstance that's not adequately taken into account here. So some incarceration is required. Given your lack of prior record, I don't think that a lengthy term of incarceration is necessary for you to be discouraged from that future conduct and for it to constitute punishment. And when I think about similar sentences I've done where people have displayed weapons but not used them during these interactions, it will be the sentence of the court that you serve 10 days in the Sheboygan County Jail with credit for 3 days previously served. You may file an application for leave to appeal if you wish. If you qualified and requested an appointed attorney, you'd have to make that request within 6 months. We're going to hand you some appeal paperwork and ask you to initial one copy for us so we have a record that we gave it to you. The other one is for you to fill out if you wish to take an appeal. And then within 24 hours of your release, I will be contacting Agent Martin.
Thank you.
But
Sure.